Can you hear me? Alright, I'll go ahead and start. In an effort to become more physically fit and active, I've recently started running. While I run, I like to make up stories in my head. On one particularly spooky night, it was about 11 p.m. It was dark. There were no cars around, no people, and no police. And I was about to run into a neighborhood into which I had never run before. I go to school at the Harriet L. Wilkes Honors College of Jupiter, Florida. Jupiter is in Palm Beach Gardens, which is a very affluent area. It's very wealthy. It's about 90% white. And one does not usually see people who look like me running around on a nightly basis. So, I had a spooky thought. I asked myself, what if I run into this neighborhood and someone shoots me, unprovoked, and claims Florida's standard ground law? Now, Jupiter is a pretty safe town, and I don't generally feel insecure when I run at night. But, that being said, I thought to myself, what would happen in this hypothetical stand your ground case? What would a court battle with these aforementioned facts look like? The reason I tell this running story is because the conditions under which I was running mimic what Thomas Hobbes calls a state of nature, which is characterized primarily as being a state wherein there is a war of all against all. In a state of nature, there is no law. In this state, because there's no law, nothing can be unjust. The notions of right and wrong, justice and injustice have there no place. Where there is no common power, there is no law. And where there is no law, no injustice. So, if there's no law, then I can, for example, drive my car however I want. But if I can do that, so can you, and so can you, and basically so can everyone. And the result would be chaos. So, Hobbes believes that this war of all against all exists because everyone is a natural equal. If we are not natural equals in strength, we might be natural equals in wit. If I can't beat you up and kill you, I might be able to devise a plot to kill you in your sleep. So, because everyone is a natural equal, this causes people to have a mutual fear of one another. In a state of nature, people are afraid of one another. So here is where the primary conflict of a state of nature lies. If we're both natural equals, and I want something, and you want something, and the law of nature dictates that we are both equally entitled to it, then who is going to arbitrate among our equally valid claims? So, to avoid these kinds of conflicts, Thomas Hobbes argues that we enter a social contract with one another, and we give up our right to do whatever we want in what he calls a mutual transference of right. Hobbes believes that we need the coercive power of the state to compel men to obey laws and avoid this dreadful state of nature wherein life is nasty, brutish, and short. In civil society, public good almost always takes precedence over individual liberty, so that men can live in peace with one another, and my liberty to do as I please can be consistent with another's liberty to do as he or she pleases. So, hopefully now you understand why my running situation kind of mimicked a Hobbesian state of nature. It was dark, there were no cars, no people, and no police around. If I was hypothetically attacked, it's likely I would have had to defend myself because I would not have had time to call the police. And Hobbes does acknowledge that a right to self-defense does not cease to exist when we enter civil society. Florida's stand your ground law mimics a Hobbesian right to natural self-defense in its spirit. Florida Statute 776.013 says that a person is justified in the use of deadly force and does not have a duty to retreat if he or she is presumed to have held a reasonable fear of imminent peril or death. Presumed. And here is where the statute appears to contradict itself. The pre in presumption suggests that a judgment has been made before one has reasonably calculated the degree of imminent peril or death. If one does not reasonably calculate whether or not their life is in danger, should they have a right under the law to take the natural right to life of another human being? Should matters of life and death be settled on something so subjective as a presumption? I ask, how exactly does one reasonably presume? The famous case of Trayvon Martin and George Zimmerman evoked debates about the implications of Florida's stand your ground law. The undisputed facts of the case are as follows. George Zimmerman spotted 17-year-old Trayvon Martin walking in his gated neighborhood, very wealthy, much like the one I almost ran into. Zimmerman began following Martin against police advice after he called to report a suspicious person, and he followed him in his car and later on foot. George's father claimed that Martin punched him to the ground and knocked him in the nose. While it is hard to imagine that a person who was knocked on the ground could have made a clear shot straight into Zimmerman Martin's heart, Zimmerman claimed self-defense and he was found not guilty by a jury on July 13, 2013. Now, if you kill someone, you've eliminated your only witness, the only person who can effectively testify against you in a court of law. If, for example, someone shot me that night I was running, and there were no people around, nobody would have been there to testify against my murder. So, Florida's stand your ground law has an immunity clause. It says that if you can prove that you reasonably presume your life to be in danger, then you are thus immune from civil prosecution. Now, it doesn't matter who you are or whether or not you killed someone in self-defense. If you ever take the natural right of life of another person, you should have to defend yourself in a court of law. Florida's stand your ground law immunity clause thereby ensures that people can sidestep the justice system, that they can't even be brought to justice by our civil process. I submit that because Florida's stand your ground law allows you to act on something so subjective as a perception of fear. So you're not meeting force with force, but you're meeting force with the potential use, your perception of someone's potential use of force, that it no longer becomes a law that uses reason. Rather, it elevates subjectivity to the level of reason and legalizes this war of all against all, which, as Hobbes imagined it, corresponded with the absence of law. Furthermore, in a country that has a history of racism, slavery, and Jim Crowism, while Florida's stand your ground law might appear neutral on its face, it is bound to be unequal in its effect. In 2013, New York Times did a study and found that nearly 70% of those who invoke stand your ground go free, and furthermore, that the defendant is more likely to prevail if the victim is black. 75% of those who killed a black person face no penalty, versus 59% of those who killed a white person. And furthermore, in nearly a third of the cases that the New York Times analyzed, the defendant either pursued the victim, shot an unarmed victim, or initiated the fight, all of which happened in the Martin Zimmerman case. So, given these statistics and the general societal paradigm that people of color are criminals, if I'm running around at night with the constant fear that someone could shoot me and invoke stand your ground, we can see how this law encourages people to be afraid of one another, to have this Hobbesian mutual fear, or what Frantz Fanon calls muscular tension. In his Wretched of the Earth, Franz Fanon argues that the muscular tension between the colonizer and the colonized is bound to release itself through violence. And whereas for Hobbes, the mutual fear between people in a state of nature exists because they're naturally equals, the muscular tension between the colonizer and the colonized exists because of their very inequality. There are stand your ground laws everywhere. It's not something that just affects Florida. I was recently in Johannesburg, South Africa for the African Literature Association's 40th annual conference. And there's this famous case that's on trial right now, the case of Oscar Pistorius. Pistorius is a white South African athlete who feared that there was an intruder in his house, in his bathroom specifically. Pistorius then proceeded to get a gun and approach this fear. And by accident, he killed his wife. Now, this case is so relevant to Florida's stand your ground law and its implications for self-defense, justice, and worldwide. You know, he, under stand your ground law, might have potentially been justified because he acted on a subjective perception of fear. Instead of retreating, he followed that fear and killed his wife. So you see, this law is criminal in a sense because it allows you to act on subjectivity and it encourages you to actually kill your victim so that there will be no witnesses. And so somehow this law ensures that killings can occur both within and outside of the sphere of law. To conclude, I want to end with a quote from President Barack Obama and his remarks on the Trayvon Martin case. He says that, for those who resist the idea that we should think about something like these stand your ground laws, I just ask people to consider if Trayvon Martin was of age and armed, could he have stood his ground on that sidewalk? And do we actually think that he would have been justified in shooting Mr. Zimmerman, who had followed him in his car because he felt threatened? Like Pistorius, he pursued that subjective perception of fear. And if the answer is no to President Obama's question, then it might be necessary to reconsider something like Florida's stand your ground law. Because, as I've tried to argue, it goes against the whole purpose of law. It increases violence by allowing people to act on something so subjective as fear. And so, to take away, I want us to think about that for Hobbes, the whole reason we enter civil society is to exit the state of nature. The whole reason why we have law is to avoid that state of nature where life is nasty, brutish, and sordid. In fact, he actually believed that every law made by the sovereign or the government is by definition just, because at least we're not in a state of nature. What would he therefore say about this law, which returns us to that dreadful state of nature, which we entered civil society to avoid? I want us to take away that Florida's stand your ground law is not properly a law. It goes against everything that law is supposed to do, in the sense that it's mocking Hobbes. It legalizes subjective perceptions, and it ensures that people can sidestep the justice system. Thank you.